So should I help you to be a bit more relaxed?
I'm okay.
You are okay.
Thank you.
Um, for how many years were you a prosecutor?
I was a prosecutor for 3 years, between 96 and 99.
And then what then happened?
I then went on to start serving my articles, but it was in the same year that I was then invited to join the magistracy, which I did. So I've been a magistrate since 1999.
So it's a total of how many years since you became a magistrate?
From 1999 to date, Chief Justice.
Is it 10 years?
My
counting is poor now. Is it 20?
It's 20, Chief Justice.
And for how many years have you been Chief Magistrate?
It's now 3 years, Chief Justice.
And you would recall, I think I visited your court with the Judge President. Were you not a Chief Magistrate already?
No, Chief Justice. It was in the same year, but it was before I came, because I came mid-year.
Were you not acting then?
I was, at the time, an acting judge in Gauteng, Chief Justice.
Okay. I thought I found you there, and I was about to congratulate you for the running of the court because I thought you were the man in charge. And when did you begin to act?
I started acting in 2014, Chief Justice.
If you add up all the acting stints, for how many months would you say you've acted as a judge?
In Gauteng, it would be 3 months, and then it would be the full year of 2018, all the 4 terms, and then the last term of 2017, and the past term, I was also acting Chief Justice.
So it's how many months all in all?
I haven't done the calculations, Chief Justice.
Okay. And was it a smooth transition or was it challenging at first?
There is a difference of approach. When I sit in the magistrates' courts, at best I interpret the law and apply it. When you sit as a judge, sometimes you have to determine what that law is. So there is quite a big transition and the responsibility as well, because when I sit as a magistrate, my judgments are not binding on anybody. They don't speak for the Republic. When I write a judgment as a judge, I speak for the division, and sometimes I also speak for the Republic, because when that judgment is referred to in Swaziland or Zimbabwe, they say this is what South Africa is saying on that point. So there's that responsibility, added responsibility for a judge that is not there for a magistrate, Chief Justice.
Yes. And I take it that it wasn't a serious challenge, though, for you to migrate from the magistracy to the responsibility as acting judge of the High Court.
It wasn't difficult because the basics were there. Learning the skills of determining the facts, appraising yourself of the law, the analysis, so that skill is there, that one gets from the benefit of serving as a magistrate.
Yes. I say it because I think not long after your acting stint, I had a chat with the JP. He was impressed by how well you were progressing as an acting judge.
Chief Justice, one recognizes the responsibility and the privilege of having to serve one's country as a judge, and therefore one does one's best to the extent that your talent and your understanding allows.
Yes. I noticed that you also hold a master's degree. What was your area of focus?
I did constitutional interpretation. It was a course one. It was not a dissertation one, Chief Justice. So I did constitutional interpretation. I did evidence as well as the procedures.
Didn't you write a mini dissertation?
I did.
What was it?
It was on jurisprudence, Chief Justice.
Yes. And what is the longest you have taken to write a judgment?
3 months at best, Chief Justice.
Yes. But generally, you've never strayed beyond, say, 6 months.
No, I have never strayed beyond 3 months, Chief Justice. Yes. I have delivered judgments mostly within 6 weeks.
And you've acted in very busy divisions.
That is correct, Chief Justice.
You have also assumed a leadership responsibility outside of a court setting as the leader of JOASA.
That is correct, Chief
Would
Justice.
you say that has contributed in some way towards enhancing your suitability for this position?
Immensely, Chief Justice, because that amongst others, JOASA, the Judicial Officers Association of South Africa, is also a member of the International Association of Judges. So it gives one exposure, firstly, to the Africa Regional Group of Judges, as well as the International Association of Judges itself. So you interact with colleagues not only within the country, but on the continent and around the world.
Yes.
So one can only benefit from that.
Yes. Now, you are 5 candidates. Now, over and above what you have said so far, just boast a bit to show us why we would be making a mistake if we were not to recommend you for appointment.
Amongst the candidates, Chief Justice, let me put it this way. In my view, in the country, you have a national body of law, Roman Dutch in its substance and Anglo-Saxon in its processes in the main. And then you have, it's generally referred to as the common law. And then you have a welter of indigenous practices, customs, and traditions underneath that. And so from what I may call loosely a philosophical point, you have 2 sets of laws within a country that are applied, sometimes depending on the location. We are moving towards an ideal constitutional state with the law of the Republic. And therefore, I bring this strength, Chief Justice, of being able to assist the country with the jurisprudence that would reflect a merger between the Anglo-Saxon Roman Dutch law as well as African law. And that is the strength that I doubt my colleagues have.
You know, just by the way, now that you've touched on jurisprudence, it's something fascinating that I picked up in a discussion with my daughter who is pursuing masters in jurisprudence.
Yes.
She says, somebody posed a question to a professor from Limpopo University, said, what do you make of the Greek philosophy and its relevance to our situation in South Africa? So, jurisprudence rather, and philosophy. So he says, the Limpopo professor said, you see, that is the problem. You think of everything with Greece or Europe as a point of reference, in total disregard of the philosophy and jurisprudence that actually obtains in Africa. How much do you think there is to harvest from a jurisprudential perspective, philosophical perspective in Africa that can be blended with what others have been able to develop?
Quite a lot, Chief Justice, because the Roman Dutch Anglo-Saxon national body of law.
Maybe before you go, part of what was said was those people were reflecting on what was happening then in their own countries, which have got no or very little bearing on what obtains here now.
I share in that, Chief Justice, because amongst others, let me give an example in the context of a family law matter. The Roman Dutch Anglo-Saxon laws are individualistic, materialistic, whereas the African law has compassion, is inclusive. So it is impossible in Africa to have your own child or your own mother as an adversary, which is what the Roman Dutch Anglo-Saxon processes puts us at. So the moment we go back to what is there in Africa, that compassion, that inclusivity, in my mind, it may also help with the challenge that we have, for instance, with family disputes. The inclusivity, the communalistic approach, the compassion. So we have a lot to learn from ourselves if we dig deeper within Africa.
Restorative justice perspective.
Exactly.
JP? Ms. Stewart?
Thank you, Chief Justice. Mr. Thulare, one of the selected articles that was put up in the comments by the DGRU refers to a statement which is attributed to you in 2010, and this is what the South African Insurance Association had to say about it. It says the South African Insurance Association has noted comments by Magistrate Daniel Thulare that were published in the Sowetan on Monday, 8 February 2010, which included, and this is attributed to you in inverted commas, any conviction for a citizen driving without a license will be unlawful if the state has failed to test that person. Won't you let us know, is that a true statement that you made, and what was the context of making that statement?
Chief Justice, I have to state, the statement was not the subject of court proceedings. It was a subject of, it arose out of a discussion that I had with, I was at the time the head of office in Davidton, and I had a discussion with the senior public prosecutor. And let me contextualize what was happening at the time in the country. People who were applying for driver's licenses had to make a call to a call center, both for a learner's as well as a driver's license. And people were struggling. The discussion arose out of an observation that it was a second person who had attended to the court in Davidton who was on his fourth learner's license. And he had a record of his struggles to get through to the call center in order to book a driver's license. And then I asked the senior public prosecutor at the time, he's now retired, Mr. Manyaka, to say, but legally speaking, if it is impossible for one to be tested, and that impossibility is at the instance of the state systems, does the state actually have the moral authority to prosecute one for driving without a license when it is failing to test or allow him to test or give him an opportunity to be tested? Be it as it may, the matter was reported because a reporter came to know about that discussion, Chief Justice, and it went on to the national newspapers. But I have to say that as a consequence of that discussion and that statement and its publicity, the whole system of testing driver's licenses was changed. And actually, it led to, amongst others, the change even of the lifespan of a learner's license. It was increased to 2 years. Some of you may recall that even the times for being tested were increased to include Saturdays and Sundays. So that's what happened. There was a reaction to that positive, and that helped the nation out of that comment.
Thanks, Chief Justice.
Thank you so much. JP Leo?
Yes. Yes, thank you. There is this case of Medina, where you said an admission of guilt. If you pay an admission of guilt, it should not serve as a previous conviction. Can you elaborate on that? It's a judgment of Medina. It appears on page 188.
Thank you, Chief Justice. I have to state, and I'm stating this with the greatest of humility, I stand by that judgment. I have noted the judgment of Judge Henny, with whom Judge Samela agreed. This matter arose, it was a review matter. And I was the scribe of the judgment. Judge Dolamo agreed with me. So as things stand, there are two views in the Western Cape on that question. And my position is I can't say Judge Henny is wrong. At best, I can say I don't agree with him. And for the following reasons. I'll give two reasons for that. The first one relates to the law at the time and the judgment upon he relied. It was the Procedures Act in terms of dealing with crime before the current act. In other words, Act 56 of 1955 that was under discussion in the NGJ trading matter. Now, there are two sections that are of particular application, in my view, in approaching this matter. And with the greatest of respect, I do not agree that the equivalence of Section 56, as it currently reads, is Section 351 of the 1956 Act. My view is that the equivalence is Section 387. And these I say for the following reasons. The procedure in terms of Section 351 is very different. You paid an amount, once given a notice, you paid an amount. The Section 351 is very clear. When you pay that amount, you are not paying a fine. At best, you're depositing security for a fine. Because the magistrate was the one who was to pass sentence. So once you are given a notice, you would pay an amount as security, and the matter came before a magistrate. So the proceedings were not completed unless they were before the magistrate, because the magistrate was the one to pass sentence. And only when the sentence is passed by the magistrate, the excess, the amount then deposited as security, may be used to pay the fine. So in Section 351, you have the centrality of a judicial officer completing the proceedings. And the section is very clear that when the magistrate then sentences, the conviction is postulated. So when NGJ Trading says the proceedings are completed by the sentencing of the magistrate, it's actually the magistrate doing the sentencing. The Section 56, no prosecutor, no magistrate plays a role. And when the person pays, Section 56 is very clear, the person is paying a fine. When it is entered by the clerk of the court, then it is deemed to be a conviction and a sentence. That happens without the involvement of the National Prosecuting Authority and without the involvement of a judicial officer. That process, where there is absence at all of the National Prosecuting Authority or a judicial officer, is a process found in Section 387 in terms of the old Act. So you can't compare the two. And that is why I am standing by the view that the conviction and sentence, which happens because the minister has determined an amount, and it happens as a result of a clerk of the court entering that amount and a reference number on the admission of guilt register, being a conviction and a sentence, it cannot be, in my view, something that we hold against members of the public. I am saying once a court, and that is the distinction, in 351, a court sentences and a court postulates a conviction, it is a judicial officer. That's Section 351. So in 387 and 56, there is no prosecutor, there is no judicial officer, and therefore I stand by Medina.
Okay, follow up.
Yes.
Section, the matter that you dealt with was, it dealt with Section 57(6) and 7. Now, my question is, does that argument also stand in respect of a person who has paid an admission of guilt in an assault common matter? If a person pays an admission of guilt in as minor offense like assault common, and does that repeatedly, will that not serve as a previous conviction?
Remember, Judge President, the law is very clear that at any stage, the prosecutors may intervene. So if the information goes to the National Prosecuting Authority that you're dealing with a repeat offender, there is room for intervention by the National Prosecuting Authority. So that challenge with regard to the conviction and sentence, all right, it's covered by that proceeding. But the point is, the position that my proposition, Judge President, with the greatest of respect, is that a conviction and sentence following a determination by the minister and the industry of a clerk of the court should not be held against a member of the public.
Minister?
Good evening, Mr. Thulare.
Good evening, Minister.
I don't want to go to the debate because I think Judge Leo is better placed than myself to engage on that one. My questions are just briefly. Given that I see that you are a president of JSC and I attended one of I can't remember whether it was a seminar or AGM.
Yeah. Okay, may I ask, Minister, that you pull, I'm struggling to hear the Minister a little bit.
Oh, given that you are a president of JSC and I think I've attended the last, it's an AGM or seminar. Which
Yes.
was in Kempton Park, and there were issues raised there, and I see there are a lot of pamphlets and lots of issues that you have raised, not only this one, but also various ones in the various newspapers and so forth. Do you think a person should be kind of some kind of adverse views with regard to a person?
I'm struggling to hear, Minister, I'm sorry.
Maybe let me bring it too close.
Thank you.
To the extent of kissing. Do you think this commission should have an adverse or dim view on you, on the views that you have expressed in your capacity as the president of JSC, which you are mandated by conference or whatever structures of JSC expected you to articulate as position of your structure?
It will be a sad day for the Republic of South Africa, Minister, if a message is sent by the commission assigned by the Republic to appoint judges to hold that expressing a view is career limiting for a judicial officer. It will be very sad.
Now, as a magistrate, I just want to, and you have acted as we have worked as a chief magistrate, and I see you have been a magistrate for a very long time. What has been your contribution with regard to innovation, digitization of our courts, and what do you think should be done to move with speed with the project of digitization of our judicial processes?
I have been involved in programs both by the ordinary functional magistracy, for lack of better terminology, as well as in their organizations, and also both as senior magistrate and chief magistrate from a management point in trying to identify what technology offers in the abstract and what the laws of the country are saying and how the two can be matched in order to make sure that both the rules and the practice directives, especially in the magistracy, speak to the technological advancement that science is making. So I have served in that capacity. There are obviously challenges because we need to work out systems that should enable judicial officers and court administration to continue to render services to our nation even when systems go off. I think you'd appreciate, Minister, it would be a sad day when a person approaching a court to seek a protection order in terms of the Domestic Violence Act, and the court staff says we are offline. So as we move progressively, there is a need for us to also consider backups. And to that extent, I have been involved in my capacity as a magistrate as well as a chief magistrate.
Thank you, Chief Justice.
Thank you, Minister. Commissioner Moimang. Commissioner Dodo.
Thank you once more, Chief Justice. Mr. Thulare, sorry.
Thank you, Commissioner.
I've read some of your articulations.
Yes.
Especially in respect of the authority of the judicial authority in the Republic.
Yes.
And what I pick up seems to be very different from the current status quo, or putting it differently, you challenge the current configuration where the judicial authority is located. Now, my question is, in line with that, what is the real problem with the current dispensation? And what are the negatives about it? Thanks.
I guess you're referring to what the minister was referring to. It would be my pronouncements on a statement of the National Executive Committee of JSC at its conference. I have to say, we are glad to note some developments. Let me give an example. Something as elementary as the Chief Justice tie may mean nothing to you. But if we as the magistracy note that he is not wearing the tie of the office of the Chief Justice, all right? We are hoping that when next he appears, he will be wearing a tie with a badge of the Judiciary of the Republic. That's what we are talking to. The office of the Chief Justice is a national department as we speak. So we were talking to the law as it stands. We are aware of the ideals, but we are talking to the laws as they stand, all right? And we were saying the Chief Justice cannot and is not a head of a national department. He is the head of the Judiciary of the Republic. He is the head of Chapter 8 framework. He cannot be the head of a Chapter 10 institution where the office of the Chief Justice is concerned. So yes, there is a need for reconfiguration. Remember, Joasa made those statements and also said, we are calling for a symposium because we acknowledge that we are not holding the monopoly of wisdom on what the state of the judiciary and its structure should be. All right? We are saying South Africa needs to start earnestly discussing. That's the discussion we are calling for.
Thank you very much. I'm okay.
Thank you.
Thank you, Honorable Dodovu. Commissioner Nam.
Thank you, Chief Justice. Good evening, Mr. Thulare.
Good evening.
Yes, I'm just concerned about something.
Yes.
You know, what worries me is if you appoint someone as a judge, you're giving that person more power.
Yes.
And you always worry because the person that possesses that power must always feel that other people can say I'm wrong and accept it.
Yes.
As a judge. Now, having listened to you, I'm concerned, and in fact, I'm a bit scared. You just made a comparison when you were asked a question by the Judge President about the convictions in terms of Section 351 and I think it's 357 that you made a comparison.
387.
387. And you made a statement that two judges, Judge Henny and Judge Samela,
yes,
have found differently.
Yes.
But you insist that you standing by your decision.
Yes.
Yes, that's my concern. At what point do you get to say, yes, I may be wrong, maybe they are quite correct, but to actually insist in the manner in which you are insisting? Because I'll tell you what worries me, is that once you reach a point where you are a judge and you are found, another court finds that you are wrong, with that attitude, it's going to be very difficult for you to accept that these judges are correct. And you might have a division where every time you are overturned by your colleagues, if you are sitting as a single judge, you are overturned by the full bench, then it becomes a problem. And just please just deal with that. I'm just very concerned.
The judgment of Medina is also a full bench. It's two judges.
Yes.
It's myself and Judge Dolamo. And there is a different view. And that's natural in a democracy. And especially in a country where we are still developing jurisprudence. So it is not the first time that two judges of the same division would hold different views. And that's why those kinds of matters would then be elevated to the Supreme Court of Appeal. So it's not a judgment of a single judge. I was not sitting alone. There is a judge who agreed with me.
No. I understand that. I'm
Yes.
talking about you. When you are a judge, you yourself,
Yes.
you must remember the position that you are articulating. You are telling us that you stand by this decision because you are involved. It's not just Judge Dalu. You are part of that.
Yes.
Now, the essence of my question is, I want to understand that if you become a judge and the full bench overturns you as a judge, you will be able to say, yes, maybe I was wrong, and you will be able to accept that. And I don't see that coming from the interactions that you've had with the members of the committee.
I have always subjected myself to the authority of a higher court. So I don't foresee any difficulty in accepting a decision of a higher court that says this is the way.
Thank you. Thank you, Chief Justice.
Commissioner Mpofu.
Thank you very much, Chief Justice. Good evening, Mr. Thulare.
Good evening, Commissioner Mpofu.
Yes, thank you. I'm just taking advantage of interacting with a legal philosopher. Doesn't happen every day. And so I'll ask you two questions, which things that have troubled me about our legal system, and whether you can just give me two quick answers.
Yes.
Yeah. If you give the answers, I'll recommend that you go straight to the Constitutional Court. But on a serious note, yeah, would you agree with the statement from a jurisprudential or philosophical point of view that that Section 25 of the Constitution is unconstitutional? And let me explain what I mean by that. Whether a section that entrenches the land ownership patterns or property relations, which were a result of the 360 years or whatever of apartheid and colonialism, can sit in the same constitution that guarantees dignity and equality. Or put differently, can we equality, whether it's gender equality, racial equality, class equality, ever be achieved without addressing the historical cause of inequality, namely the land issue?
I come from the school of thought, Commissioner Mpofu, that the laws of any country are the products of two main things: its history and its logic. So you can't extract history from the logic. Otherwise, the laws cannot be owned by those it is meant to serve. So they can't say this is our law. And you're going to have problems with then abidance as well as compliance as well as enforcement. That would be my short answer.
Okay. I think you're going to the cave. So, no, that's fine. Thank you very much. Okay, that's a philosophical answer. The second one is, yes. The second one is there's a debate, and that relates to something you said about values, the values of selfishness, individualism, greed, survival of the fittest, and all that. Those kinds of values which underlie what you might call the capitalist or liberal democracy systems, versus the African values of communalism, collectivism, and so on, and compassion, as you said. There's a raging debate, maybe that's an exaggeration, in our jurisprudence right now between the values of Ubuntu, infusing the values of Ubuntu into our law of contract as an implied term of fairness on the one hand, and pacta sunt servanda, which is just a pompous way of saying contracts must be honored. And there are judgments which fall one way or the other depending on who's sitting on the bench, on which of the two philosophies should predominate. In other words, should we respect contractual law if people voluntarily sign a document, then they must be held to it because they did it with their open eyes and they can't complain later? Or should we assume that in every contractual relationship, particularly if there's an inequality of arms, that Ubuntu and those kinds of values should be used to arbitrate a dispute? If you are familiar with that dispute, where do you fall, and do you think that it's a useful debate, or can it be resolved through what you call the rejection, maybe that's a strong word, of foreign philosophies?
As we march towards a true South African jurisprudence, we have to acknowledge that in the writings of a judgment, sometimes what one may call the social engineering or the judicial philosophy of a judge comes into play. And it is a reality that we must deal with. But we must acknowledge that we are in Africa, and the ethos of the African people must find expression in our law. We have charted for ourselves a yardstick against which all laws should be measured, and that is the Constitution of the Republic. So that's the top point. But as we march there, we will of course struggle with whether you call it the ideological jurisprudence or the judicial philosophy of each and every judge on how it comes to bear on a matter before them. That's the reality that we have to deal with as we march. But marching towards a constitutional ideal, we should, if we want to bequeath a South Africa that we all want for our children and our grandchildren.
Thank you, Chief Justice.
Many thanks, SC. Commissioner Msom.
Thanks, Chief Justice. Just one question from me, Mr. Thulare, and it relates to an article that is quoted by DGRU, where I'm not sure whether you were talking about corporal punishment, but you seem to have suggested that punishment of the child is a necessary evil to help correct behavior. And you made reference to the age, I think the age between the ages of 6 and 10. Is that your view still, or were you quoted out of context in the light of the recent constitutional court
It was a general statement on punishment, not necessarily corporal punishment, but the Constitutional Court has spoken, and that's it.
Well, because of that statement, if they say they are bringing children to me, I'll send some of them to you. Honorable Lucas.
Thank you very much, Honorable Chief Justice. Good evening, Mr. Thulare.
Good evening, Commissioner.
I have been quite covered, I saw, but I just wanted on a lighter note to say it is heartwarming to say that you are a member of the Association of Women Judges. We appreciate the fact that really you can identify with us as women.
Thank you. If I can just say, I'm not there to assist women. I've internalized their struggles.
Oh, thank you. That's wow. That's wow. And that's why I said it's on a lighter note. But just also your relationship with Pick and Pay, because I see amongst everyone that they've nominated you, there is one from Pick and Pay, a specific Pick and Pay. And
yes.
I wondered what was your relationship with Pick and Pay?
No, look, I was emotionally touched. And pardon me if I cry. I was dealing with children from the Davidton area as well as the Watville areas. And I came to know that there were children who were actually eating on shifts. If you ate today, you could not eat tomorrow. And that is the reality. Some people believe that when we talk of poverty, it's only in the rural areas, but it's not. So that touched me. And that is why I had to do something about it, to make sure that at least the children that attend the court where I was head of court, at least on that day, they have something to eat. And if we can help them, if we can help them carry something home, we should do that. So it had nothing to do with any funny relationship other than the struggles of grandmothers who stay with children whose mothers have passed on. And it is in that context that I approached Pick and Pay, and I'm grateful to Mr. Skuman, the man at Pick and Pay Faramir. When I invited him and he saw what I saw, he agreed to provide food for those children at the courthouse, and to the extent that we can, we also made packages for them. Thank you. I'm sorry for my emotional state.
Thank you.
Commissioner Gogo.
Thank you, Chief Justice. Good evening, Mr. Thulare.
Good evening, Commissioner.
How are you?
I'm trying. I've been touched on something.
No. You need not to worry about that. We understand. I've noted that you were recommended by many organizations.
Yes.
Including the Black Lawyers Association.
Yes.
What I have learned...
Preamble, is it, unless it's strictly necessary?
It's necessary, Chief Justice. What I have learned is that when I received the pack, there were complaints against you, which I believe at the time the Black Lawyers Association recommended you, they were not aware of them. I want you to talk to us about the complaint by Hole and Amos.
All right. I will start with the Amos matter.
If it is possible to be brief, it would help.
Thank you.
Thank you.
The matter went to the High Court, and Judge Shea wrote a judgment. I submitted it to the commission after learning about that. He found no trace of bias as alleged, and all the other allegations that were leveled against me. I had made a decision that Mr. Amos was not yet ready to be a senior magistrate. At that time that I made that decision, there had been 4 senior magistrates who had been sent to Stellenbosch, 1 by the head of office and 3 by the Magistrates Commission, who had made the same conclusion, that he lacks the capacity to train a magistrate, which is a requirement for the training and guidance of juniors is a requirement for being a senior magistrate. I also had issues with his sensitivities towards gender. Let me just cite one example. On one morning, a female magistrate calls him or informs him that my child is ill, I need to take the child to the doctor. I've made an arrangement for early in the morning. Should the diagnosis allow that I come to the office, I will come to the office. If it doesn't allow, I'll let you know. His response was, you must make a decision whether you are a mother or a magistrate. I didn't have the alacrity, or let me say, I was unable to say that person, that kind of mindset was a mindset that was ready to lead an office with two other females on the staff establishment. And as I say, Judge Shea had written a judgment. There are two terms that he uses to describe Mr. Amos. And he says he's officious and pugilistic in his attitude. So that is to the extent that I will refer to Mr. Amos. With regard to Mr. Hole, there was a complaint by him against the regional court president in the Northern Cape. The Magistrates Commission at the time could not send a regional court president and a chief magistrate for the simple reason that both were serving on the lower court management committee and they knew each other very well. So I was asked to go there. The proceedings, they were recorded. Amongst others, Mr. Hole said the gist of the complaints that were there attributed to him were not by him. And obviously we came back. I wasn't alone. I was sitting with another regional court magistrate, Mr. Mahango. And obviously if a complainant says, I am not the author of these complaints, what do you say? The result is obvious. And that's what we reported back to the Magistrates Commission. I know that he was unhappy about that. Subsequently, I learned about it. But as things stands, Mr. Hole has never, remember in terms of the Magistrates Act, if you are not happy with the conduct of another colleague, you lodge a grievance with the Magistrates Commission. I've never received one to date. Thank you.
Follow-up, Chief Justice. In respect of Amos, he says the problem between you and him is that he refused to, he challenged the employment of the daughter of a deputy minister as a magistrate without interview. And in respect of Hole, he also referred to the way you described him in the report that you gave. A comment?
Let me start with the Hole one. I was not the only scribe of the report that was written in respect of him. As I say, I was in the company of a regional court magistrate. If you understand the hierarchy within the magistracy, you'd immediately pick up that I was basically the junior partner in the team. I had a regional magistrate and I was a senior magistrate at the time. We wrote a joint report. We agreed on what we reported on. And what we reported on is what we had observed. In respect of Mr. Amos, remember I arrived in the Western Cape on the 4th of June 2016. I found the complaints of Ms. Madinda on my table, the complaints against him, against her. And that's the lady who's referred to as the minister's daughter. To date, I don't know if Ms. Madinda is actually the minister's daughter. It may be so, I do not know. I don't even know, because remember, there's no cabinet minister that I'm aware of who carries the surname Madinda. So I looked through the reports. What I established was that, and let me take you through the training of a magistrate. The mentor must go through the records of the candidate or the aspirant magistrate. It is expected that as you go through and pick up problems, you sit down with the magistrate, you point out the errors so that there is progress in reporting. What was happening, and what I read from the reports, was that those adverse comments that were found by Mr. Amos were forwarded to the chief magistrate as complaints against her. And this is why 4 senior magistrates said, He cannot train because it is expected that you should discuss this with the candidate. You must correct the candidate and take it through. I made the decision after reading those I think it was in my second week in Cape Town to say, and the other thing is the correspondence indicated that they were not on speaking terms. So you can't have a mentor and a mentee who do not speak to each other. And that is the reason why I then made a decision to say Ms. Madinda must then come to Cape Town, and I assigned a senior magistrate to train her. So I was never aware, I'm not aware even today that Ms. Madinda is the daughter of a minister. I've seen that in the correspondence of Mr. Amos. I've heard him say so. I don't know that, but I can assure this commission, nothing that I did was ever informed by who Ms. Madinda was or who her parents were. As I say, they were already, when I arrived on the desk, 4 reports of senior magistrates who were saying the relationship and the training that's going on. And that's why I removed Ms. Madinda to Cape Town. Thank you.
Thank you, Chief Justice.
Thank you so much, sir. President Maya.
Thank you very much, Chief Justice. I won't be long. Good evening, Mr. Thulare.
Good evening, President.
Just a quick question relating to the AGM, the Johannesburg AGM, to which Minister alluded earlier.
Yes.
One of the utterances you are alleged to have made at that AGM by the legal brief, among other media outlets, is that the heads of court, a powerful body within the judiciary which meets at the pleasure and invitation of the Chief Justice, make key decisions affecting courts without the representation of magistrates. That is, they hold meetings without involving the magistracy. Now, I just want to find out from you if you made this statement, and if you did, if it is in fact an accurate state of affairs.
The statements that I made are contained in the report. I mean, the statement that the NEC made. It is correct that JOASA raised concern about, remember what is happening. You have, let's take the classic example of committees of the heads of courts, all right? The decisions relating to the establishment of those committees and what they actually do, to the extent that JOASA is aware, chief magistrates are not involved at those meetings. The decisions as to how the judiciary, as an arm of government, interacts with the other arms of government, including the administration, those decisions are made where chief magistrates and regional court presidents are not present. Remember, we have regional court presidents and chief magistrates as members of JOASA, and they contribute to the discussions within the organization. So it is against that background. I can put you at ease and say to you, Madam President, the thinking is, if you look at, for instance, Section 45 of the Constitution, which speaks to Parliament, you will see that there is Parliament, there are 2 houses. But Section 45 provides for joint meetings and joint committees to be established at that seat. To the extent that the reports are made to the organization, we do not have such a framework within the judiciary. When the heads of courts determines, for instance, to establish certain committees, the regional court presidents and the chief magistrates are not there. Our advice is that they are there when issues relating to court operations are discussed, not at that governance level. And it is against that background that JOASA made those comments, yes.
Thank you, President. Commissioner Masuku?
I'm covered, Chief Justice.
Thank you. It's my turn, and there's a preamble. It's necessary.
Yes.
By the way, I'm the one who caused what the minister refers to as documents to be circulated, and for good reason. I must begin, Mr. Thulare, by appreciating your clarity in explaining things and your boldness. I explain your boldness with great appreciation because I like people who speak truth to power rather than people who would be writing anonymously about the institution of which they are part and parcel. It's a plus to be bold, whether you are wrong or right, to say, but this is where I stand, regardless of who you are confronting with a statement. But I've got a few questions. One of them is the one that the President alluded to, and I'll tell you why. It is right that judicial officers speak on any platform. But contrary to what you and the minister are agreeing to, it is never right for them to say what is untrue, regardless of what organization they belong to. You cannot come here and say because you are in Joada, yes, the minister is a fool. He shouldn't have been appointed. We don't know why such an idiot was appointed in the first place. You will be held accountable for that statement, even if you were speaking under the auspices of JOASA. Otherwise, this body would be highly irresponsible to recommend you for appointment if you utter such a statement under the cover of JOASA. That's where I'm coming from. First question. Yes?
I think maybe I should correct that part. I don't agree with anything. I just asked him a question whether I just asked him a question which he answered. I never agreed or disagreed with what he said.
No, I was just addressing the issue of holding a person accountable for what he or she is saying on behalf of an organization. You can hold a person accountable. That's where I'm coming from.
Yeah, I'm saying I did not agree nor disagree
Yes.
with his answer.
Yes. Now, is it correct that heads of courts hold a meeting at the behest and pleasure of the Chief Justice? And I'll tell you the importance of it maybe before you answer.
Yes.
You see, people criticize the judiciary on the basis that we are biased, we make statements or judgments that are not substantiated, either by facts or law. So you can't just arrive at a conclusion. It must be properly substantiated and it must be true. So my question is very direct. Is it true? Is it correct that the heads of courts meet at the behest and pleasure of the Chief Justice?
Chief Justice, to the extent that, let me start by saying, it saddens me that the issues that have been raised by an organization which is not here, which I am no longer president of, and on whose behalf I cannot speak, without a proper mandate to speak for, that I am, my interview for judgeship is actually used to iron out whatever the issues are that the organization raised. I have to state that. But having stated that, Chief Justice, to the extent that JOASA is aware, the Office of the Chief Justice invites, at least as regards the leadership of the magistracy, to the meetings. There is no, to the extent that the organization is aware, there is no structure that says these are the sittings agreed to at a meeting, as I say, a joint sitting of both the higher and the lower courts as envisaged or akin to what is envisaged in Section 45 of the Constitution. And it is against that background that these comments were made.
No, let's clarify it. You were talking about the heads of the higher courts, or what are otherwise referred to as the superior courts, which don't involve the magistrates in the decisions they take. So I repeat my question, and please give me a clear and direct answer. Is it true? Is it correct that the judges' presidents, the president of the SCA, judges, heads of courts at that level, when they meet at the behest and pleasure of the Chief Justice?
That is to the extent that the organization is aware that pronounce itself like that, Chief Justice.
Who told you so? As a judicial officer who appreciates the importance of truth and asks people to raise their hand to tell the truth, the whole truth and nothing but the truth before they speak before you, who told you?
Chief
As
Justice?
as
Yes.
an individual or as JOASA?
Chief
Please,
Magistrate.
Let me complete my question, please, my
Yes.
brother. That colleagues meet at the pleasure and the behest of the Chief Justice. Where do you get that from?
Chief Justice, to the extent that the organization is aware, and I am forced now to speak on its behalf, I don't have its mandate. To the extent that the organization is aware, contemporaneous with the invites of the leadership of the magistracies meetings with the Chief Justice, the heads of courts are invited.
It's at the behest and pleasure?
To the extent that we are aware, yes.
What rendered it necessary to make that public pronouncement? Why couldn't you ask how it actually happens?
Chief Justice, as I say, I think the greatest difficulty and the greatest omission is the participation of the magistracy in the governance structures of the judiciary. And that's the point JOASA was raising.
Now we'll come to that. That's a
Yes.
separate thing. Let's not conflate issues. Let's go to the next point. Is there engagement between the leadership of the judiciary and the leadership of the magistracy, or are decisions simply imposed on the leadership of the magistracy without a discussion?
At operational level, yes, not at governance level.
No. I don't understand. Is there an engagement between the Chief Justice and other leaders of the superior courts and the leadership of the magistracy, or is there no engagement?
Chief Justice, I am answering the question.
Yes.
In relation to governance of the judiciary, all right, the magistracy does not participate. In relation to court operations, yes, they do.
Which issues relating to the governance of the judiciary are discussed by the judges' presidents, which are not discussed with the leadership of the magistracy?
On the 3rd of this month, Chief Justice, there was a statement made for the judiciary. If you read that report, there's nothing about the magistracy. That's but one example.
Oh, it is not correct, sir. If
The
you
performance of the magistracy is not there, Chief Justice.
Let me explain, my brother. I'm sorry. It is not correct. Sorry, ma. Oh. Yes. Okay. Let me wrap it up in this way. I was concerned by this one thing. The statements made about the judiciary not being a fiefdom or a kingdom. The statement be made about, there are a number of things being made in the statement which concerned me deeply because I don't think they are true. Judicial kingdom, over concentration of power. I think they are unfortunate. That's what I wanted to put across to you, and they are not correct. I thought I needed to make it, to put a point across to you. There are statements here that are incorrect that I think should not have been made. You can conclude, I leave it there.
Chief Justice, the unfortunate part I would agree with. But I think the point that the organization raised, to the extent that I'm aware, is that there is need for the magistracy to have a sense of belonging within the judiciary, because it is a Chapter 8 institution. And that's its position.
Yes.
And if to the and there is a need, as I say, we were there. I was personally present on the 3rd of this month, Chief Justice. I was wearing my gown. It was a report on the judiciary, but it did not report on the performance of the magistracy.
I avoided it because Honorable Lucas intervened. We indicated in the document, in my statement, that there are, as far as the magistracy is concerned, with the assistance of Judge President Musi, we've only been able to go so far as to develop the key performance indicators. It has not been possible to come with the performance report, but we promise that it will come in future. That statement is there. That is the truth that I was insisting on, that whatever we say, let us be truthful as judicial officers.
Chief Justice, I will close by saying I think there is a need perhaps for the leadership of the judiciary to engage with JSC on these issues.
May I excuse, thank you, my brother, thank you very much. Otherwise, I really like your boldness. Keep it up. My only plea would be just check your facts before you speak publicly.
Thank you, Chief Justice. Thank you.